Trade International Show. Today we have from securities industry authorities a message from the Home Office regarding new security legislation changes to be presented by CEO Bill Butler.
Good afternoon, and this may be one of the more exclusive presentations of the day, but I'm glad you managed to find space out there. I could put a radio mic out and come and sit with you and do this personally. What I want to do today is to talk about what we've been trying to do in private security regulation since 2010, to give a brief outline of the current position, and then to talk about where we're going next on regulation. In spite of the number of people here, this is vitally important for those who are involved in the leisure and entertainment sector. There are going to be significant changes to the way we regulate private security and businesses who use and provide private security. In 2010, our then chairman, Baroness Ruth Hennig, made an announcement at our conference, and she said she was going to change the way regulation was delivered if she could persuade the new government to do that. And she said we would build on the standards that we'd already established for individuals and around quality in the approved contractor scheme, but that we would shift our regulatory effort towards businesses involved in the private security industry rather than individuals, that we would seek as part of that to reduce the burden that fell on individuals, that we would provide better, quicker and cheaper regulation, and that we wanted industry to take up increased responsibility. Those who buy and supply private security, we wanted them to pick up responsibility for how that was delivered rather more. In the autumn of 2010, the government, as part of their public bodies review, or you will probably know it better as the bonfire of the Quangos, said of the SIA that we would no longer be an NDPB and there would be a phased transition to a new regime. That's actually the phrase that appeared in government documents. I still think it looks like the cryptic clue in a Sunday Times crossword puzzle, and I'm still not quite sure what the answer is. An NDPB is a non-departmental public body. By that, I think what they meant was that the regulation would be done outside the government sector rather than inside it. But we've been working to try and keep ministers happy on that ever since. Home Office consultation on the future regulatory regime was issued in November last year, and that proposed a phased transition from the current arrangements to a business regulation scheme, a significant change in how individuals are licensed, and a reduction in regulatory cost and burden on the private security industry as a whole. The closing date for that consultation was the 15th of January 2013, and the response to it was, by government standards, enormous. There were the best part of 800 separate responses from individuals, from businesses, from training companies, from police forces, charities, and individuals interested in the area. 800 might not seem a lot for a national consultation, but normally if they get 200, they think they're doing quite well. I think for same-sex marriages, they got about 250,000, but we weren't in that league. But of course, civil servants do have to read every response they get, so that kept them fairly busy for the first part of the new year. But generally, what people said was they supported the direction that the SIA and the Home Office were proposing. What are they proposing? Well, the first element of that is a move to business regulation. All businesses who provide contracted private security services, and in the case of door supervision sector, those who provide in-house security will in future need to be regulated. They will be regulated as fit and proper. By that, we mean that they don't do anything that they shouldn't. The directors and those who own the company haven't got criminal records, but also that they file accounts properly, that they pay tax and national insurance properly, that they hold the professional indemnity insurances that are required for the sector that they're working in. None of the requirements will be additional. None of the requirements will be what good businesses aren't already doing. But we suspect that in a lot of areas, particularly in the DS sector and particularly around tax and national insurance, there are a lot of companies who have a lot of ground to cover. In addition to that, businesses will have to demonstrate that they are competent in their relevant sector to the equivalent of the British standard that's relevant. That doesn't mean they have to go out and get the British standard, but they will have to demonstrate that they meet those standards. We believe that's important because the British standards are the standards that the industry itself says should apply. We don't think they're particularly onerous, and we think that providing private security at below those levels is dangerous and not where we should be. Businesses will also be able, if they choose, to take responsibility for some elements of individual licensing. They will have to say they want to do this, but we can't see any reason why checking people's identity and checking that people are properly qualified to do their job can't be done by the business that they're employed by. Good businesses already do this. Why do it twice? Of course, what we can do, which businesses can't, is look at people's criminal record, including spent convictions, in making a decision on whether somebody should be licensed, and we will continue to do that as the regulator. We will tailor these arrangements for micro businesses, small businesses, and those who are entering the regime, because obviously you can't demonstrate that you've filed accounts when you haven't operated as a business. So we will tailor the arrangements, but the standards we will require will be the same, whatever the standard of, whatever the size of businesses. When we talk about businesses, most sole traders will be excluded. But by sole traders, we mean traders who are genuinely sole. We don't mean people who say they're a sole trader, but actually employ 30 or 40 people through agency routes in order to deliver a business. But genuine sole traders will be licensed as individuals, not as a business. The fees that we charge will recognise the focus of regulation, i.e. businesses, and the relative size of businesses, probably in terms of the number of people that they deploy. For individuals, the licensing will continue to require the same sort of standards that we have now. This is not about reducing individual standards or letting it go, or individual company schemes. Individual licensing will still apply. As I said, identity and skills will be checked by businesses and criminality by the regulator, which I think will still be called the SIA. We will also ensure that there is robust and proportionate enforcement of the new regime. And as currently, what we want to do is to focus not on people who are properly licensed and who've got a license, but on people where our intelligence tells us that they are not properly licensed or that they should have a license and aren't licensed. Learning and qualification standards for individuals, we would like to shift to business-related bodies. We think it's right that the regulator ensures that standards are maintained, but we think the training standards should be something that the industry is heavily involved in and takes ownership of. In exactly the same way as for businesses, they take responsibility for business standards. We also want to build a clearer relationship in our regime between employers and employees. We're in rather a daft situation at the moment where if you're a business and you ask us what the status of an individual who you employ's license is, we tell you we can't tell you that because of data protection issues. We are working on that. We are building up consent from individuals so that we can share with employers their licensing status, and that will be built into the new regime. We think that will benefit employers, employees, and the regulator in terms of monitoring where people are in the system. Since 2010, we have delivered, notwithstanding our waiting for legislation from the government, on a number of things. Our services in individual licensing are much quicker. 4 years ago, we were quite pleased that we were able to do 60% of license applications in 35 days. We now do nearly 90% in 20 days. And due to the better service that we operate, you can renew by telephone. If you're a business, you can renew online. Due to those things, we quite often process licenses in the same week that we receive the application. In fact, and this is a true story, we did have a complaint about 18 months ago from an individual who the last time they'd renewed their license had taken 4.5 months. So he'd actually booked a holiday with his wife on the assumption that he wouldn't be able to work for several months after he applied. And he actually got his license back within 5 days and therefore couldn't take the time off. So took the trouble to write and complain that we'd ruined his holiday. I don't mind that sort of complaint. Costs, we've reduced our costs very significantly. We continue to do that. I think it's absolutely vital that we reduce costs to the minimum level consistent with a plausible regulator. I don't think we can reduce them so that the regulator doesn't exist, otherwise there's no point in having the regime. Fees we reduced from £245 to £220, and I expect that trend of reductions to continue into the new regime. As I've said already, we've also focused our compliance. If you look on our website, if you follow us on Facebook or on Twitter, you will see that most of our compliance activity is against businesses and against businesses who are ignoring the requirements of the law in respect of regulation. By doing that, we take them out of the equation. By going after businesses that are involved in the trafficking of illegal immigrants and employing illegal immigrants, we take out the training qualifications that those people have wrongly acquired. All of that benefits legitimate business, which can get on and take its market share without being undercut by people who are operating on a criminal basis, or in some cases as a front for organised crime gangs. So the future. I've said all these things are going to happen, but I can't make them happen without new legislation. The minister responsible for the SIA, Lord Taylor, has made a commitment, and every time I see him, he's absolutely adamant that this will be driven through, that there will be secondary legislation in place by October. Now, that legislation will allow us to introduce business licensing so that we will be open to approved businesses from April 2014. A consequence of that is if we meet that timetable, it would become a criminal offence to operate in a private security business without being properly licensed, probably from the spring of 2015. We need some primary legislation through Parliament, through both houses of Parliament, in order to do this properly. In particular, we want proportionate powers to deal with licensed businesses. At the moment, my powers are rather draconian. I can prosecute you, or I can tell you that I'm going to prosecute you. That applies, for example, if you are not wearing your badge, or if you're a licensed individual and you fail to tell us that you've moved house and give us your new address. That's a criminal offence. Under a business licensing regime, it would be a criminal offence if you, for example, failed to send us an annual return on your business. It seems to me that that's ridiculous that you criminalise those things, and we want legislation that will give us administrative sanction so that A, we are not criminalising administrative failures, and B, so that the people who create problems through their administrative failings are paying for it rather than being subsidised to do that by other licence payers. That legislation is promised as soon as possible, and we are still awaiting announcements on when that will be. If it doesn't come fairly soon, we'll obviously miss the general election, and that will cause problems. But the Minister tells me every time I see him that he's working on this. Staff responsibilities will change. At the moment, it's very much on the individual in terms of how things work and getting licensed. A lot of that will shift to businesses. Responsibilities for standards, both for the business standard for the operation of a company and for the standards we want to train people to, will shift to businesses. A big change, and I want to be absolutely clear about this, is that the introduction of business licensing means that businesses will have to pick up their fair share of paying for the regime. At the moment, the regime is funded entirely from the fees that we charge to individuals. The vast majority of those individuals pay their own licence fees, quite often out of minimum wage. Businesses benefit from being in a regulated regime and need to pay their fair share. That means that it's going to go from currently paying nothing in most cases to paying something. The other thing that we want from businesses is increased involvement and engagement in making private security work. And the reason we need private security to work is because that's what keeps people safe. The reason that people can go out in the UK nighttime economy and on the whole enjoy themselves and go home safe is a lot to do with the calibre and quality of the individuals and businesses that provide private security in that sector, the door supervisors in particular. We cannot carry on making the quality of that service entirely dependent upon the price that we charge. We cannot go on pretending that people are safe where we have one individual overseeing the security on the door and in a bar. We need to recognise that there is a price. I recognise that there are already costs in every industry and that times are hard. But we cannot let people's safety suffer. And it's an unfortunate fact that the part of my business where things really do go wrong is in the nighttime entertainment sector. And we are now up to 17 individuals since 2004. That's 17 members of the public who have died whilst being restrained by door supervisors. And we cannot continue to ignore that risk to the public, as well as the many injuries that are caused to door supervisors themselves by not having properly trained, properly deployed people working for responsible, properly licensed companies. That's the end of what I wanted to say and the end of my sermon. Thank you very much for listening.